All right, that was more from Friday outside the Denham, Massachusetts courthouse, where we are awaiting a verdict in the trial for Karen Read. I have a great legal panel here today with me to discuss all of this and to break it down for you. We have trial attorney and federal litigator Alexis Rosenberg, and along with that, we have criminal defense attorney Paul Townsend. They've just joined me. So we've seen a lot of Karen Read supporters outside the courtroom these last few months, but not as much from the prosecution supporters. Alexis, why do you think that is?
Well, I mean, I think that a lot of people have been moved by this particular trial. And then in the beginning, we had all of those hearings that were going on with regard to the protesters in her defense because they believed that it is police corruption. And now we have this verdict. They've been out for over 24 hours. So I think that's going to bring out more of the protesters on both sides.
Exactly. And, you know, like I just said, the protesters are out there mainly in support of Karen Read. What do you think the reason is for that? Do you agree with Alexis? Or, I mean, why do you think we have so many of them out there and not as much for the prosecution, Paul?
So I largely agree with Alexis. I think it's a little bit surprising that you don't see more pro-prosecution protesters here, especially because the decedent was a police officer. And typically when a cop is killed, you get a lot of other police officers and friends and family who are very vocal. It's very common that in a case where a police officer dies to have a lot of people who are very interested in the verdict. That blue wall really does come into effect. So it is interesting in this case that you haven't seen that as much. But I think now, as the case is kind of coming to a close, you know, the jury's been deliberating for quite some time. A verdict is, if it's going to happen, likely to come fairly soon. Now you're seeing everyone who has an interest in the case kind of coming together and making their voice heard. Exactly.
All right. Before we analyze this any further, let's see what some of those Karen Read supporters had to say.
Not one person here has ever forgotten about John O'Keefe. Okay, and that needs to be said, and you guys need to hear that, because not one person here has forgotten about John. You cannot get justice for John O'Keefe by prosecuting Karen Read. It just can't happen. You can't have both things. We are all here for Karen Read. We are all here for John O'Keefe, and justice for John is the main goal. You need to exonerate Karen Read so John can get justice. Amen. And at this moment, we're going to take a moment of silence for John.
Let's take a moment of silence for John.
Moment of silence.
Moment of silence.
Silence.
All right, on the subject of Karen Read supporters, last week, at least 2 supporters went to the Veterans of Foreign War building where the victim's family was stationed to await the verdict. The Read supporters claimed that they could have been trolled into going there under false pretenses, believing they needed to assist a fellow Karen Read supporter who was allegedly in distress. Now, one of the Read supporters issued an apology that stated, quote, "It deeply troubles me to think that my actions may have added to your grief. I wholeheartedly assure you that I would never want to hurt a grieving family." My legal panel is back with me to discuss, so let's talk about this. Alexis, one of the things that I'm thinking here is that these outside supporters might give some insight into what's actually going on in that jury room. During this morning's note, they said, and I'm going to read this for you, quote, "Despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds." Alexis, what do you think that could mean? I mean, even though twice now the judge has said, go back, the second time with the actual charge, the Rodriguez charge. But this note, to me, sounds like it's very serious and they're never going to get through this deadlock.
Terry, I agree with you. I mean, I think that that is definitely a sign of that we're probably going to have a hung jury. The judge cannot send them back for the 3rd time. So that was the last time to bring them in and send them back. So, but I think based on that note, which is drafted, it seems like a lot of thought was put into it, that we're most likely going to come back with a hung jury.
Yes, and you know what, Paul? If we come back with the hung jury, all of these weeks, all of these witnesses, what happens after that?
Well, there's a couple of things that could happen. Basically, the prosecution needs to make a decision about whether or not to try the case again or to potentially find a way to resolve the case. A lot of times what happens after hung juries is the prosecution reaches out to the defense attorney and says, maybe instead of murder, we can go with, maybe criminally negligent homicide and time served, something like that. A lot of times a fairly generous plea bargain might be offered after a hung jury, because trying a case a second time presents a lot of difficulties that you don't see the first time. All the testimony is in, it's all fodder for cross-examination in a second trial if any witness testifies any differently than they did in the first trial. So it's very possible that they will say, you know what, we believe Karen Reed is a murderer, and so we're going to try the case again. They can absolutely do that. But it's not uncommon to see a case get quietly resolved after a hung jury.
Exactly. And you know what, Lexis, what do you think is holding them up? Do you think it has anything to do with that lesser included charge? I mean, maybe they don't think she intentionally tried to kill him, but maybe it was an accident, it was manslaughter. Do you think that's what's holding them up?
Terry, I agree with you. The bottom line is that the prosecution did miss really making a connection as to the car impacting, John. There were some missing components that I don't think that they hammered home and provided the evidence to the jury. The lesser charge, really, they should have charged her not with murder to start with, based on what was presented at this trial. And they most likely, with a lesser charge, the jury would have already come back.
Exactly. I agree with you 100%, both of you. Thank you for your wonderful analysis. All right, we have to take a quick break, but stick around as we switch gears to Atlanta, Georgia, to cover what you might have missed in the Young Thug racketeering trial out of Atlanta. We'll be right back. So we've been listening to a hearing outside the presence of the jury surrounding an ex parte hearing involving YSL affiliate Kenneth Little Woody Copeland. Still with us, our trial attorney and litigator, Alexis Rosenberg, and criminal defense attorney, Paul Townsend. Paul, I'm going to start with you. There is so much to unpack here. We talked earlier about possible appeals. Could this entire ex parte communication, this meeting, I mean, we had the prosecution there, we had Copeland there, we had the judge there, no one from the defense team was there. There were investigators and other people who were there, and still rightly objected to this. And actually, I think he could have gotten a mistrial, but if not, this is a solid ground for appeal. What's your thought about that?
Harry, this is insane. I don't think that people who are casually following trials or viewers of the Long Crime Network really get a sense of just how ridiculous this is. Ex parte meetings, like the one that happened here, are huge problems. It should never happen. Anytime one of the parties meets with the judge to discuss a substantial facet of the case, that is wholly improper. Now you're talking about a witness for the prosecution, with the prosecutors, with investigators, and the judge, and a court reporter, and the judge's secretary, and no defense team. That is unprecedented levels of misconduct. And the judge is now walking the entire courtroom through everything that went wrong here, and yet still seems to be blaming the defense attorney for bringing this out. The defense attorney finds out about this through, he notes very clearly, surveillance footage caught him having a conversation with the witness's lawyer, which I guess is how Brian Steele finds out about this entire meeting, which takes place between 9:10 and almost noon. And of course, the defense attorney brings it up. You would have to. I can't think of a single defense attorney who wouldn't be jumping up and down screaming, this is ridiculously improper. This is cause for a mistrial. This is point number one on an appeal should Young Thug be convicted. This is such a ridiculous string of events that this judge just walked the entire courtroom through as though it's just another Tuesday. I struggle to believe it.
You know, it's funny, I'm sitting here and I'm looking at Brian Steele, looking at the judge, and I think his disbelief is as large as our disbelief. It is something I've never seen in all my years of practice and in all my years of analyzing cases. This is something that a judge should have never done. It's the easiest thing not to do. Don't have an ex parte communication. And holding Steele in contempt, it's just something that I absolutely think this case should have been thrown out. And I do think, I agree with you, Paul. I think this is ground number one for appeal. All right, we have to take a quick break, but don't go anywhere as we continue covering the Young Thug racketeering trial out of Atlanta, Georgia. We'll be right back. All right, Judge Glanville there is just reading about all these cases, what's right for ex parte, what's not right for ex parte. I have with me still Alexis Rosenberg and Paul Townsend. Alexis, I'm going to ask you this question. One of the things the judge read was, what is appropriate for an ex parte meeting? And he said, according to the rules, you have to talk about scheduling or administrative or procedural, tactical, non-substance. The meeting he had was filled with substance. How does he think he did not violate these rules?
I mean, listening to this is like watching a one-legged duck swim in circles. I don't even understand. It's so confusing. It definitely was not calendaring. He's latching on to that it was an emergency situation and there was no discussion about substance. And I'm not getting... this witness was represented by counsel, as the judge said, but yet she wasn't capable of explaining the immunity agreement. They needed the judge there and they needed the prosecution there to explain that to him. I mean, I don't think this is supporting what he's trying to support by any means.
Exactly. The more he reads, the more it sounds to me, Judge, you've violated your own rules as to what consists of a ex parte meeting. You've done just the opposite. Everything you talked about there, the immunity, the fifth, and what it entails, and having all of those parties except for the defense, to me, it just is, he's digging a deeper hole. I'm glad that he's giving the record to the defense and to all the parties, because this is exactly, as Paul stated earlier, this is what is going to go up on appeal. All right, we have to take a break, but right back. Don't go anywhere. We'll have more for you in the case in Atlanta, Georgia against Young Thug. Stay with us.